All right, and this is family violence and criminal trial division.
Yes.
So the state was to make a global offer. Has that been done?
No, Your Honor. We're here for the discovery today
All
on
right,
the robbery because the other one, the one that deals with family violence has not been indicted.
all right, family violence, if you'll come forward.
And I've spoken to the state, but they seem want on the criminal side defense of it.
So this is
This is a robbery.
Gonzalez, Israel Gonzalez. It's 2025 PF 20635. And so today it was supposed to be a global offer that is made. And are you on the PF case?
Yes, sir.
All right, so where are we on discovery on the PF case?
I've been getting discovery, but I get this new discovery as once it reaches the point where it's going to be indicted, it keeps them in discovery. But I've gotten some discovery on it, and the discovery that I did really recently viewed entirely was on the robbery, which
Mhm.
is the same situation or the same complainant. Okay. Now that's the one I received a whole slew of evidence and on that, on videos and discovery. There is one thing that I believe it's not in there that I didn't see was any phone records connecting my client with the complainant.
All right. So,
And just to have you know, Your Honor, this should probably be a trial.
okay.
That single sentence, "This would probably be a trial," changes the entire temperature of the courtroom. This is defense counsel signaling we are not bluffing. Trials are expensive, time-consuming, and risky for both sides. When a defense attorney says this out loud, it pressures the prosecution to tighten their case or sweeten an offer. It's also strategic timing. Discovery isn't finished, indictments are pending, and the defense is essentially saying, if you're not ready now, we'll let a jury decide later. And make no mistake, judges hear that loud and clear.
So what is outstanding? Is there anything outstanding on the assault peace officer or the robbery case?
I told Miss Carrillo that I need more time to look because there were people ahead of her
Yes.
in my staff,
Yeah.
and I've not had an opportunity to look and see if what she's asking for has to come to her.
All right, so let's step back and the state will review and then I'll call you back.
Okay, Your Honor, I gotta be in two of, can we come back tomorrow? Because I have a motion to amend his GPS. Okay,
No, because we're in trial, so I'll just confer with the state and then I'll take
All
this
right,
matter. All
okay.
right, thank you.
you take that up when you take up the motion?
You'll need to speak with the state and see if they're ready to proceed on your motion.
Okay,
Thank you. Who's here on Angel, Joe, Ohoel, Varela? And are y'all ready to proceed on the motion?
Yes, Your Honor.
All right. Probation, this is a motion to revoke.
Good morning, Your Honor.
Good morning. All right, the court is calling 2019 CR 7765 State versus Angel Joel Varela. Could I have parties announced for the record?
Ashley Jones for the state. Here at court before Mr. Varela, Your Honor.
And are you Mr. Varela?
Yes, Your Honor.
All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? And did you understand it?
Yes, Your Honor.
Are you the same Angel Joel Varela who's placed on deferred adjudication in 2019 CR 7765 for the offense of burglary of a habitation with intent to commit assault on June 13, 2022 for a period of 4 years? Is that you?
Yes, Your Honor.
All right, state.
Yes, Your Honor. We are going to go forward on violation of condition number 1 from the supplement on first amended motion to revoke. That is on or about the 17th day of March, 2024 in Yuma County,
Oh,
Arizona.
I'm so sorry. I don't have the supplemental.
Okay.
All right, did you review the supplemental motion to enter adjudication of guilt and revoke community supervision with your attorney as well?
That's the one I signed, correct?
No. It's telling you,
Oh, yes, yes, Your Honor.
all right, the supplemental motion is telling you what allegations the state is saying that you committed that are a violation of your probation. Do you understand?
Yes, Your Honor.
And did you review the supplemental with your attorney as well?
Yes, Your Honor.
All right, they're just gonna get that for me because I don't have it. All right, thank you. Sometimes it gets lost in the system. Thank you. All right, state, you may proceed. Oh, it's still the First Amendment. I thought you said supplemental.
No, I corrected First Amendment here.
Then I have that. All right, let's proceed.
All right, on or about the 17th day of March, 2024 in Yuma County, Arizona, the defendant Angel Joel Varela committed the offense of aggravated driving under the influence in violation of condition number 1.
How do you plead to that, true or not true?
True, Your Honor.
And the state will waive the remaining violations, Your Honor.
Any objections to the state's waivers?
No, Your Honor.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, Your Honor.
Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor. The proposed agreement is that the court grant the the state's motion to enter adjudication of guilt, revoke the community supervision, and sentence the defendant to 3 years in the Texas Department of Corrections.
All right. Is that what you're requesting, counsel?
It is, Your Honor.
All right. Are you asking the court to follow that agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right. And can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right. You can lower your hand, state your name for the record.
Angel Joel Varela.
All right. What have you completed on probation?
Well, Your Honor, on probation, I was going to work, being a law-abiding citizen, just trying to do my best to stay out of the way, or be a good father to my kids, and really just my cousin, he passed away. I was really close to him.
Just talking real quick,
Yes.
while I'm thinking of this, when we signed the paperwork, I told him he did have a limited right to an appeal, and you did
Yeah.
ask him if he was waiving his right to appeal, so can I just explain to him what that means?
Sure.
Okay.
All right. So what have you completed?
Having a job and being there for my kids.
I mean, everybody does that.
And while I was in prison, I completed anger management classes. I completed a cognitive behavior classes.
So you've been sentenced on the other cases?
Judge, he was sentenced to up to 2.5 years in Yuma, Arizona. I believe he did a 1.5 years. If I'm reading the
Do
judgment,
you know that cause number?
yes. You ready?
Yes.
It's number S1400CR 2024000523.
All right. So you completed cognitive and that was while you were in custody?
It was just anger management
Cognitive anger management, there's another one.
and behavior analysis.
And that was while you were in custody?
Yes.
And that happened while he was on probation.
Okay. All right. This is what the court will do. The court is finding violation of condition number 1 true, and that's the violation with regards to aggravated driving.
Listen carefully to how the judge delivers this: firm, controlled, and final. The affirmative finding of family violence is not just symbolic, it permanently alters the defendant's civil rights, most notably a lifetime prohibition on firearms and ammunition under federal law. And those conditions, no contact, no unsupervised contact with minors, are the court drawing a hard line between accountability and public safety. This isn't just punishment. This is the system saying your actions have long-term consequences.
The court will grant the state's motion, revoke, sentence you to 3 years in the prison. This will run concurrently with S1400. Did you say CR?
Yes, Your Honor.
CR 20240005 2-3. There's an affirmative finding of family violence. There's to be no contact with Liliana Martinez. There's to be no unsupervised contact with minors. There is a $1,500 fine. Time and money will run concurrently. And according to your plea bargain agreement, there's no outstanding restitution. Is there anything else with regards to sentencing?
Not from the state.
Judge, it's just, he wants me to make sure he's getting his back time for all the time he did Bear County, which I know I think he's entitled to, right?
Yes.
And then you're giving him his credit for the time that he served on this case in Yuma?
Yes,
Thank
and
you.
it's running concurrently. And legally, I must give you credit for any time served.
Okay.
So that's, sometimes I don't say it because it's automatic and your attorney knows that it's automatic. But sometimes we forget that people who are not in the legal field don't know. So the record is clear. You're entitled to credit for any time served that you're in custody on this case. And you're entitled for any credit for any time that you were in custody out of state, as long as this warrant was pending. So if there was not a warrant pending and you were doing time somewhere else, then you're not entitled to that credit. Once a motion to revoke was filed on this case, then you're entitled to credit from that point. And your attorney will check to make sure that that is accurate. All right, and if for some reason you go to prison and you find that it's not accurate, what will usually happen is we will receive a letter, it will be reviewed. And usually if everything is correct, what you're saying, someone will double check it. And then when they double check it, I'll sign a motion or an order granting you any time that you feel that's appropriate. You understand?
Yes, Your Honor.
And that's proven to be appropriate. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over that, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go with the record. Do better. Otherwise, you're going to find yourself living your life in somebody's prison or somebody's jail. You understand?
Yes, Your Honor.
All right, good luck.
Thank you.
You're
Merry
welcome.
Christmas.
Judge.
Thank you. Thank you.
Appreciate it.
Anaya Gifford.
Yes, Judge.
All right, the court is calling 2023 CR 5888 State versus Anaya Gifford. Can I have parties announced for the record for the state?
Megan Galloway for the state.
For the
Mauer
defense?
for defendant, Your Honor.
And are you Ms. Gifford? All right, you entered a plea of guilty on October 16th. There was a request for a PSI. And according to your plea bargain agreement, punishments be assessed at a cap of 8 years in the prison. There's a $1,000 fine. The state is opposed to your application. And there's restitution of $12,000 to Mr. Holtzworth. Have both parties had a chance to review the PSI?
Yes, I've reviewed it, Your Honor, and I have no objections.
I don't have any objections, Judge.
All right, and are there any witnesses?
The state has no witnesses, Your Honor.
No, Judge, I just have argument.
All right, the court will hear argument. State you're opposed.
I am, Your Honor. I'm asking for the court to deny the application and sentence her to 8 years, reserve the rest of my time.
All right, just one moment. All right, you may proceed.
So, Judge, I want to point out, from looking at this, Ms. Gifford was sentenced to a federal prison for I guess, a conspiracy charge that I think this case arose out of. She was released, I think, actually with a warrant in place from the federal penitentiary, and then made bond here. And I don't know why this was not included originally with the federal prosecution, or if in fact, I don't have a copy of the federal PSI, and I can't really determine whether or not the complainant in this one is actually a complainant involved on the federal case. And if the court notes, there's a restitution amount among all the people who were sentenced to $1,235,000. Ms. Gifford's currently paying restitution to federal supervised release, which is the federal equivalent of parole, for this, the federal charges. And she's employed now. She lives in Georgia, and I guess is capable of paying restitution on this case. If the court grants her deferred, obviously it would have been better for her if this case had been included in the federal sentence. And I think, how much did you do?
I got sentenced to 57 months and I served 30 months.
So if the court doesn't grant her application, I ask the court to give her credit for the time she spent in the federal penitentiary. Since this is in fact, I think, out of the same fact pattern, and I think the same conspiracy. But I would ask that she's been released, and she's paying restitution now, that the court grant her probation and let her pay restitution on this case as well. Like I said, I have no way of determining what restitution was ordered. I would assume it's jointly and severally among the conspirators, but I don't know if the complainant in question on this case was one of the complainants on the federal case.
All right. And my understanding in this case, and correct me if I'm wrong, I'm going from memory. This is a case where the complainant was told that their grandson was
That's correct.
in
That's right.
dire straits and that they needed someone to take their money. I'm sorry, they needed someone to withdraw money to save him from the dire straits that he was in.
That's correct. Your
All
Honor.
right. All right, State.
Judge, so what Mr. Mauer represented to the court is correct. There was a federal prosecution.
Excuse me just a second. All right, I can see you're pregnant, so there's no need to
I'm not trying to show
Okay.
that off.
all right, thank you. You may continue.
There was a federal prosecution that occurred out of San Diego. And the court is aware of the $1 million restitution that they were ordered to pay out of San Diego. I didn't have anything to indicate that this victim was included in that. However, this was a very big conspiracy that they put together where they were targeting elderly individuals. The victim in this case is 80 years old and was targeted because of that. Called and told that his grandson was in danger and that he needed to spend $12,000 immediately.
This is where the emotional gravity of the case becomes undeniable. Targeting an 80-year-old victim isn't just fraud, it's exploitation of fear, trust, and vulnerability. Prosecutors take these cases personally, and judges often do too. Notice how restitution becomes the centerpiece here. Not punishment, not prison length, restoration. The court is asking one simple question: can you make this right? And for many viewers watching, this is a chilling reminder of how sophisticated scams prey on our parents and grandparents.
To provide safety to his grandson. And the $12,000 is agreed upon. The evidence did point back that it did go into this defendant's Chase bank account. And in the stipulated evidence, the Chase bank records are in there where the account is belonging to Anijah Gifford, Your Honor. And so we would ask that you order the restitution if you do give her community supervision, but I just don't believe that she's a good candidate for community supervision. So we would ask that you deny the application.
All right. I'm not saying I'm going to deny it or grant it, but when are you going to have this $12,000?
If I'm being honest, I can't give a specific date, but I can make payments, whatever you order. If you order for me to make a specific payment, I can work on that.
All right, here's my question. Do you have any loved ones?
Yes.
Mom, dad? All right, let's assume that someone's picking up the phone and calling you and saying, hey, your mom has been in this accident and we're going to arrest her unless $12,000 is paid, right? So look at that as that type of urgency. So when are you going to have this $12,000? Because I can tell you, and your attorney can probably tell you, the person who's 80 years old and you scammed them out of $12,000, they're probably on a fixed income. They worked all their life to save that, and you came in because you didn't want to get a job and you wanted to build your happiness off somebody else's misery. So I want to know when you're going to have this $12,000, and I can tell you the latest is going to be in February.
I can do that.
I think that's a good idea, Judge.
All right. And I'm not saying I'm going to grant it, but what I'm saying, that would probably help your case tremendously because he needs his $12,000. So, Ms. Ferguson, recall this for sentencing in February, and you need to have the $12,000 and you need to be here in court.
I will be here.
All right.
I'll get her to sign a reset form.
All right. Thank you. We'll see you back on February 2nd. At that time, you need to come with $12,000. And state, does that need to be in cashier's check, money order?
Yeah, usually there's an upfront restitution form we have to fill out.
I can do that.
All right.
Yes, ma'am. Thank you.
You're welcome.